Welcome back. We now bring you the conclusion of today's cases.
Yes.
Mr.
And
Justice,
the answer is?
I'm not going. I'm not going there. That, in my submission, is inappropriate in this particular context because that engages the court in assessing the efficacy of the legislation. If there is, as I say, a rational basis, or I think as the Chief Justice used alternate expressions, a reasoned basis, some good reason, lack of arbitrariness, a reasonable link, we've crossed the line which enables Parliament or a legislature to act. Then if it acts unwisely or in an unefficacious way, then that doesn't render the legislation unconstitutional under this type of analysis. It may be determined in a particular case that the legislation suffers from overbreadth, which is a standard which this court has already articulated. But to start considering the efficacy of legislation, in my respectful submission, it would be inconsistent with what this court has said in other areas. Parliament may be unwise. A provincial legislature may be unwise, but being unwise doesn't equate necessarily to acting in a constitutionally impermissible manner. Much has been said about the possibility of imprisonment. I mean, if we're going to talk about that, much has been said about the possibility of imprisonment. But I ask the court to bear in mind, since I think about 1974, 1975, we have the discharge provision of the criminal code, because the concern that's expressed is that people who are convicted of possession of marijuana will have criminal records, and that is true in some cases. But Parliament has, many years ago, provided the judiciary with the means to dispose of a case without giving a person a criminal record if, in the view of the court, that's an appropriate disposition. Mr. Caine, one of the appellants before you, who was found, I think it's a fair inference, having just smoked a marijuana joint in a truck or a van parked in a public parking lot, was prosecuted and received an absolute discharge. He has no criminal record for that particular offense. So the mechanisms are there. So if you're going to look at what Parliament has done, look at the complete legislative package, which includes sentencing provisions which would result in no criminal record. I'd like to say a few words with respect to the argument that has been advanced, which I would categorize as a plea that this court find a freestanding liberty interest, regardless of the possibility of incarceration, in the use of marijuana. What I have categorized in the factum on page 36 as the right to get stoned, or the no right to get stoned. Okay. Marijuana, in the context that we're discussing it, is a recreational drug. Alcohol is a recreational drug. There are other recreational drugs. And there is very little support in the jurisprudence of this court and in the jurisprudence of other courts that have looked at the marijuana and drug issues for finding a freestanding liberty or security of the person interest being impaired by the simple prohibition, because that argument would mean that even the decriminalization model recommended by the Commons Committee, and which is, of course, something that my learned friends alluded to, this has been discussed recently by the government, that would fall as well. Their position is, I get to choose what I ingest. That is not, that in this context, where you're dealing with a recreational drug, does not fall into the category of a fundamental life choice or a fundamental personal choice. And I rely on the recent discussion of this topic set out on page 37, in part on page 37 of the factum by Mr. Justice Bastarash in the recent Blencoe case. It would, in my respectful submission, trivialize the charter, to constitutionalize the right to smoke marijuana or to use any other drug. Because if you accept that argument, the person who is using heroin for the first time is voluntarily using heroin. The argument would immediately go on the thesis propounded by those opposite me to the prohibition on heroin and cocaine on their face violate Section 7 and have to be justified under Section 1. Okay. They say whatever you want to use, you're entitled to use. And this Court has never, in my respectful submission, taken the Charter that far, and there's been clear indications that the Charter does not go that far. So it's not a matter of I choose to do it, therefore a prohibition infringes my liberty interest and the state must justify. Whether it's marijuana, whether it's another drug, whether it's alcohol, whether it's the fact that I don't think speed limits on highways are appropriate. Right? I have the freedom to drive at 120 kilometers an hour if I choose to do so. A speed limit infringes on that liberty interest and the state must justify it, and then I suppose we get into the debate as to whether the speeding laws in Germany with the Autobahn are more efficacious than those under the Highway Traffic Act of Ontario or the Motor Vehicle Act of British Columbia. So in my submission, there is simply no support for the proposition that there is any freestanding right to ingest drugs for non-medical purposes. See, if I could just I appreciate I'm being a bit about moving a bit about the map on this, but there were things that I had hoped to say that I didn't get out at the appropriate time. But I ask you to bear in mind that in terms of the criminal law power and sort of the assessment of for charter purposes of the efficacy of legislation. Look at what happened in the Berryland Canning case, which is referred to starting at the bottom of page 43 in paragraph 110 of the factum, because that's a case where cyclamates, a food additive, was banned, and the company which wanted to use or had used cyclamates in its products and was being prohibited from doing so went to the federal court and said, there's no real reason for this. My experts say that cyclamates are a harmless substance. The government's response was, well, our experts are concerned that it may be a harmful substance, but we're erring on the side of caution. Okay? The legislation was upheld. I use that as an example of where the other side's argument, even on harm, takes us. The debate between the experts. What's harmful, what's not harmful? Is it sufficiently harmful? And bear in mind that when you're dealing with, even in the food additive context, somebody who violates the law and acts contrary to the prohibitions in the Food and Drugs Act is subject to prosecution for which potentially, albeit not in respect of the company, but that's neither here nor there, but the offense itself is one which, if prosecuted, could result in some cases in imprisonment. So that attracts liberty. And so are we going to now, in the food additive, in the review of the efficacy of drugs, pharmaceuticals, have the courts engaged in someone wants to sell something, they sell it, they're prosecuted for selling it because it's a non-approved drug, and then they say, well, there may be some harms associated with it, but there are not enough harms. I say, and I'm repeating myself, that the courts are not well placed to deal with those issues. If the courts determined that there is a rational basis for the decision should stand. And it's that margin of deference that I say is integral to our Western democratic society. My learned friend, Mr. Burstein, I think began by saying that the marijuana laws are a failure of the democratic process. I disagree with that. Whether you like them or not, the marijuana laws are an example of the democratic process in issue. My learned friend would have it that the process failed because the result is one that his client does not approve of. And that's not the measure of the functioning of a democratic process. By its very nature, when laws are enacted, some people do not like the laws. But it's not a popularity contest. It's not a matter in the joint statement of legislative facts. We have polling results. Okay. Polling results could change. Constitutional provisions don't, constitutional standards do not change. So it's not a matter of, let's take a poll, and what does the Globe and Mail poll say today about public reaction to marijuana? What does the National Post poll say today about this law or that law, which carries a penal sanction? Okay. The polling results may be matters that politicians will wish to take into consideration, that the Parliament or a legislature may wish to look at, but it's not a matter for a court. Okay. If the politicians look at a matter, consider it, perform their function, and pass a law which is rational, that is all the Constitution requires of them, and it cannot demand more. Okay. The electorate may demand more, but the electorate has the means of dealing with it in our democratic society. So I say that there is a limit, there is a baseline, and the baseline is as I've attempted to articulate in my argument. If I could move on from this, because there are some other issues I'd like to touch on, very briefly, with the greatest of respect to Mr. Malmo-Levine's submissions to the court, Section 15 is simply not engaged here. And I address this beginning on page 50 of the factum in paragraph 129. The right to deal, substance orientation, with all due respect, those are not activities protected by the Constitution. Okay. Wanting to use or wanting to sell marijuana is not an immutable personal characteristic. Mr. Malmo-Levine and those who support him may very much want to use marijuana. But indeed, on the very evidence they lead, they're not compelled to use it. They choose to use it. So a matter of choice does not fall under Section 15 of the Charter. If it did, then just about everything would fall under Section 15 of the Charter. So this Court has set a standard for analogous grounds for testing legislation for discriminatory purposes, and simply put, the marijuana laws can't be found to be in violation of Section 15(1) of the Charter, and I rest for the most part on the argument that's set out in the factum. I'd like to say a few words, and I've already touched on this, about the procedural error that's alleged by Mr. Malmo-Levine in the conduct of his trial, because it has the potential of being an important issue, an important practice point for the criminal law generally, if this Court should wish to deal with it. And the argument in that regard starts on the bottom of page 51 in paragraph 135.